My name is Caleb Lee. I'm Asian American, and I stand with Team Enough Bay Area to fight against gun violence. We know that gun violence primarily affects Black and brown communities of color and results in a prison system in which Black and brown individuals are incarcerated and locked up for long periods of time. I want to change this, fight the system, fight the power, and make good for all.
My name's Becky Cameron. I live in Stockton. On Thanksgiving 2011, my son and his family were awakened to 43 bullets coming through the window of the room where they slept at his father-in-law's house. Fortunately, there were only injuries, my 6-year-old granddaughter and my daughter-in-law. In 2018, on my birthday, the Parkland school shooting took place. I decided at that time that it was time for me to get involved and become a part of the solution.
Hi, my name is Kari. I'm part of Brady in Riverside, California. It's not right that people are vulnerable to gun violence every day, and any place. I work for gun violence prevention because it's the right thing to do.
Hello, my name is Maddie Scott, and I'm the California president for Brady United Against Gun Violence. I'm also the founder of Healing for Our Families in Our Nation and the chapter leader for San Francisco Mothers in Charge. This is my son, George C. Scott, who was killed 24 years ago by senseless gun violence. His case remains unsolved. Why I do this work? Because I want to stop the killing and start the healing. I want to go to graduations and not funerals. I want justice for my son.
Hello, everyone. That's a very powerful video. My name is John Lowy. For those who don't know me, I'm Vice President of Legal and Chief Counsel at Brady. And it's been my privilege to work at Brady for the past 23 years. I look forward to the next 23 years. And first off, thank you all. I can't see you on my screen, but thank you all for all the work you do. I mean, I think that our supporters, activists are really the folks who inspire me and all of us at Brady. And certainly California, that's, you all have done such phenomenal work. You're a model for the nation. I'm going to give a very quick overview of our work at Brady Legal and then turn it over to two of our amazing lawyers on our team. First, Christa Nicols, who will talk about our constitutional work, and Erin who will talk about our gun industry reform litigation. Briefly, and some of you may know this, over 30 years ago, Brady decided to create a legal division, a legal department. They thought wisely that it was important to take on the gun lobby and the gun industry in a forum where it had less clout, less lobbying power, less influence with politicians, and that was the courts. That may seem a little quaint nowadays, where the gun lobby has great influence in the courts. And since that time, we at Brady Legal have been involved in a wide variety of litigation to change the way the gun industry does business, and also to create a constitutional precedent to support gun laws, and also to use the legal system to prevent gun violence in other ways. We've been involved in over 250 lawsuits in over 40 states. And in our liability work, we've won over $60 million in verdicts and settlements. And all of our work is pro bono. We don't charge anything. We just do it for the same reason that all of you do your work, to save lives. There are a few major categories of our work. The first is constitutional litigation. I'll put that first because Christa will be talking next about that. And a lot of that is fighting in the courts for a sensible construction of the Second Amendment, to make it so the Second Amendment recognizes that the sort of gun policies that we all want can remain on the books. And a lot of that work involves filing amicus briefs, but sometimes we represent cities and counties and even states in their fight to defend their gun laws. And we also file amicus briefs in other areas that Christa will talk about. The next category, and this is probably most of our work, is gun industry reform litigation. And that is mostly representing victims and survivors of gun violence in lawsuits against gun dealers, manufacturers, distributors, websites, and other actors that contribute to gun violence in some way. And one thing you should know about us is we are active litigators. There are a lot of public interest groups that quote unquote bring cases, but what they really do is they do great work, but they'll hire a law firm who will fight for them in the courts. We work with law firms, but all of us, are in courts, or nowadays on Zoom screens in courtrooms. And we have cases all around the country. We try cases, we argue in court, trial courts and appellate courts. In fact, we've been involved in over 40 states, state and federal courts. The third category of our cases is to challenge dangerous laws that impede gun violence prevention in some way. Some of you may know this. Years ago, when Florida enacted a law that penalized doctors if they talked about guns to their patients. So if they followed the accepted protocol and told parents, store your gun safely, they could lose their medical license. So we brought a lawsuit against that law and got it struck down as a violation of the First Amendment. And there are other examples of that sort of litigation. And then there's various other types of litigation. I think you've heard from Kelly Sampson, who's another great member of our team, who does our racial justice work, and we are beginning to explore litigation in the racial justice space as well. And another important aspect is, while we do litigate ourselves, we work with lawyers and law firms around the country, and those are extremely important. There are over 35 law firms, most of them very major law firms, that work with us pro bono, and we could not do a fraction of what we do without their help. So with that brief introduction, I'm going to turn it over to Christa Nicols, who will talk about our constitutional litigation.
Hi, everybody. My name is Christa Nicols, as John mentioned. I am litigation and constitutional counsel at Brady. So I work on some of our liability cases, but also with our constitutional program, which encompasses the amicus brief work that we do that John just mentioned. Our work with that is pretty extensive. As John mentioned, we filed over 200 briefs as friend of the court. Sometimes Brady will also argue in those cases in court or as amici or co-counsel. And the briefs really do defend gun laws or gun safety laws that range from assault weapons bans, high capacity magazine restrictions, waiting periods, and safety devices and things like that, really supporting the gun safety laws that Brady wants to enact, but also defending against laws or lawsuits that would undermine gun safety measures, just as John mentioned with the Florida case. But aside from that, the efforts to draft these briefs serve another purpose of being thought leaders in the space and highlighting the countervailing right to live that should not be undermined or infringed by an extensively broad reading of the Second Amendment. So what I'll do is I can give an update from 2020 on the types of briefs we've been filing, many of them in the Ninth Circuit, because the Ninth Circuit in California in particular is the epicenter of gun violence gun litigation. And then I can also talk a bit about some of the Second Amendment cases that we've been watching and what that might mean for cases that the Supreme Court will hear.
So I'm going to interject with some questions for Christa. I mean, first off, we actually all watched an argument just a few hours ago on Zoom in a case in the Ninth Circuit, Young versus Hawaii. If you can talk about that one a little bit.
Yeah, so this was a second hearing for this particular case. It was en banc, which means a panel of 11 judges reviewing a decision from a 3-panel judge below. And the law was challenging Hawaii's law that had a show cause restriction on their license to carry handguns in public. And what's at stake with this is that it presents the opportunity for the courts to expand the narrow holding in Heller. So in Heller, or District of Columbia v. Heller, the court held that there was a right to a handgun for self-defense in the home. And the challenges to restrictions and permits outside of the house presented opportunity to expand that to extend a right to self-defense from the home to in public, which will really have potential impacts for all types of gun laws unrelated to permits. So as John mentioned, they heard the hearing today, and it seemed to go well. It's hard to necessarily tell what way the court will go based on the arguments, but the attorney defending the law did an amazing job, and pretty hopeful. So we'll stay tuned for that.
Yeah, I thought it went well. Neil Katyal was arguing for Hawaii, so you may have seen him on Rachel Maddow and other shows, but he's a great lawyer. So then there's a challenge to California's large capacity magazine ban, and that's on appeal. I mean, if you can talk about that a little bit.
Absolutely. And this, again, in the Ninth Circuit, I think was maybe one of our first peeks into some of the implications of the types of judges that are being nominated to the court recently. It was a very, in my opinion, flawed decision in expanding the right in Heller, but essentially the law challenged a provision of Prop 63 in California, which banned large capacity magazines. And well, it expanded the ban that it was in place. So it extended a ban from purchasing or transferring to a ban on possession. And the court read Heller to put the amount of bullets that the magazine could hold within the core of the Second Amendment and struck the law down. So we've actually filed a brief along with the other gun violence prevention briefs to ask the Ninth Circuit to rehear that case with a panel of 11 judges, just as they did in the Young case this week. And hopefully if the court decides to do that, we will be able to file a substantive brief in defense of that. We know that large capacity magazines have very severe impacts, not only on the amount of people who are injured, but the severity of those injuries, and all of the social science backs that up. And it's a reasonable common sense restriction that really shouldn't be subject to an unresponsive branch of government based on ambiguities in the Second Amendment.
Yeah, and just to interject a little, as Christa said, the Heller ruling, which I think was incorrect, but notwithstanding that, it was very narrow and it left a lot of unanswered questions. And these cases that we're dealing with now are courts resolving these unanswered questions. And the Supreme Court has not yet heard one of these cases, but it might. Yeah, if you want to see read a scary conservative right-wing opinion, read the trial court opinion in Duncan v. Becerra, and it's very unsettling with their expansive view of the Second Amendment. Mm-hmm. So then there's the Road versus Becerra, the background check on ammunition case.
Yes, this also comes out of Prop 63. So this proposition, I think it believed to pass by 63%, which made it very easy to remember. But it's background checks on ammunition, which are shown by the research to really drastically reduce the amount of gun crime with guns from prohibited purchasers or in a secondary illegal market. And there is no reason to expand Heller's holding to prevent these types of reasonable transactional restrictions or requirement that you just show ID when you're buying ammunition. So to, again, extending the Second Amendment beyond what Heller required when the law is ambiguous is overriding the ability of communities or state and local governments from enacting popular and common sense solutions to gun violence, which is a very multifaceted and complex public health issue, and it should be left to the representative and responsive branches of government. And there's no questions. Then there's Rep. Becerra, which is again similar story with an assault weapons ban, and those are the cases kind of at the appellate level in the Ninth Circuit. And outside of that, there were kind of two main buckets of topics in which we filed briefs. And the first was minimum age restrictions on buying a gun. So putting restrictions that somebody over 18 but under 21 either can't buy certain kinds of weapons or buy weapons at all. Two of those were in district courts in the Ninth District in Washington and California, and the other were in Florida and the Fourth Circuit. And they're essentially also backed up by the research that the neurological studies with adolescents shows that younger people are more prone to impulsive behavior and that these restrictions are effective and reasonable. And the second bucket, that was state preemption laws. So sometimes states that will regulate firearms comprehensively through some kind of state act, and it'll have a provision that says that localities can't enact anything related to firearms. And so what that does is it prevents mostly cities that have interests that are at odds with maybe some of the more rural areas in the state when it comes to gun violence prevention. It prevents them from tailoring the law to meet the specific needs in the city. So two of these actually were against Pittsburgh, arising out of a law that they passed in response to the Tree of Life synagogue shooting that would have banned assault weapons, put background checks on ammunition, and then also enacted an extreme risk protected order. They were essentially challenged as Pennsylvania has a preemption statute. So what we argue in these amicus briefs is that there is a constitutional right within the state constitution for home rule, and that it's really damaging to efforts for cities to find creative solutions to really address the gun violence issues in their communities if they can't go further than whatever minimum level of regulation exists at the state level.
Yeah, and one theme in all of these cases is that, as Christa said, these are complex issues, as we all know, and that legislatures are the ones who should decide it, and that it's outrageous and inappropriate that you have judges who have no background in this issue necessarily, deciding should a state be able to restrict handgun possession to someone who's under 21, given the neuroscience of brain development. I mean, those are not the sort of issues that judges deal with or should be dealing with. And that's sort of, if you're arguing Second Amendment with people, I think that's sort of a major issue, is who's best to decide these issues, democratically elected representatives or, unelected judges, or in some cases elected judges.
Absolutely. And the last is, as John mentioned, we are branching out in areas that maybe are less directly related to the gun cases in which we filed briefs. And we've done some work in that space, particularly with the litigation around the Postal Service lawsuits filed against the Trump administration based on the administrative changes that would impact the ability of people to vote by mail. So we filed 3 amicus briefs in federal courts in Pennsylvania, DC, and Washington in support of states' attorneys general that were trying to halt or reverse those changes. It's our position that gun violence prevention is a democracy issue, and that there's a disconnect between how popular common sense gun violence prevention laws are and what actually gets reflected in the law. And until we can, have a government that allows, is actually representative of the voters' will, we're not going to be able to change the laws in a way that will actually save lives. And the second is kind of a niche area of the Federal Communications Commission. So there is a statute regulating the internet called Section 230 of the Communications Decency Act, and it makes it very difficult to bring lawsuits that Brady would like to bring against like reckless online gun sellers. And so we filed a comment for a regulatory hearing with that, just demonstrating what that broad, unnecessary reading of the statute does for our work. So if there's no questions on that, we can talk a little bit about what we're looking at going forward. So Brady's going to continue looking for opportunities to file briefs in cases that are at the intersection of racial justice and gun violence prevention. We're definitely interested in some of the litigation that might arise out of armed militias at polling places, and democracy issues and voter access issues. And we're currently drafting a brief to support Everytown's litigation to require the ATF to treat ghost guns as firearms under the Gun Control Act. So very busy, we're excited. But if there's not any questions, then I guess we can move to, I see one.
And I mean, maybe just to move things along, since we're running behind, we can talk after Erin talks about the liability cases, about where the Supreme Court is, what it's done, and we can also look forward to the coming Supreme Court battle that we're in now. So let's just turn to Erin Davis, talk about our gun industry reform litigation. I think you're muted. In Erin's defense, at the argument that we heard today, judges were constantly talking with their screens muted. And
yes, I very much enjoy litigation. I struggle sometimes with technology, so it's great to join you all virtually. I am happy to report that the ice cream truck, which has been driving up and down my street all night and parking in front of my house, has stopped officially, and hopefully I'm really excited to be with you all this evening and share a little bit about the great liability cases that we do. I am the senior counsel for trial and appellate litigation at Brady, and my work primarily incorporates working on our liability cases. John spoke a little bit about Brady's history, its missions, its goals, Brady Legals, and I just want to emphasize before I jump into some of the details on our cases that all of our cases are brought on behalf of really, really brave and passionate clients who don't want the same thing that happened to them and their family to happen to somebody else. So, they're always the heroes of all of our cases, and it's always a pleasure to work on their behalf. All of our litigation is impact-driven litigation, and our goal is for it to really have a nationwide impact. We have cases all over the country, rural, urban, conservative, more liberal districts, and we work all over the country on these cases. Right now we have about 23 active liability counsel where we are pro hot beached into the case and counsel of record. And in addition to that, we provide tremendous amount of support to private attorneys and encourage them to bring their own gun industry liability cases. We enjoy speaking, we like giving webinars, we have plans to hopefully put together some instruction manuals and maybe even a book. And really the purpose of all this is to share our work with other people and really end and limit the gun violence epidemic with our work. Since the COVID lockdown, our team has not stopped. We have we filed, I think, at least 6 new liability cases since we've been remote. And we've settled some really, really impactful cases, including one that I'm going to talk about in a minute, which went on for 15 years. So before I jump into sort of the details of our different buckets of liability cases, one thing that's quite different from the cases that Christa spoke about is that our gun industry liability cases are really not about the Second Amendment. These cases are about gun dealers and gun manufacturers having negligent systems in place that prevent them from following the rules, the laws, the industry best practices that, you know, a federally licensed gun dealer and manufacturer are required to follow. We obviously get some defendants who try and frame these as Second Amendment cases, but they just aren't. And really some of our best jurors that we've had and some of our clients are gun owners. And part of the reason for that is that they understand that there's a right way and a wrong way to sell guns, and they understand that that guns should not be given in negligent ways to dangerous people. So those are obviously some themes that are present in a lot of our impact-driven cases. We basically have several different buckets and different types of cases that we litigate. One is a gun industry sales and distribution cases. We do cases on assault weapons and marketing cases. We do product safety cases. We do online sales and safety cases. In many of our cases, they bring up challenges to the Protection of Lawful Commerce and Arms Act, which is an immunity statute that we end up fighting in many of our cases. And, you know, we certainly also are always expanding into new areas, potentially ghost guns, which is a, you know, new area of crime guns that are turning up in California. So I'm going to jump into some of the details of these different types of cases and hopefully share some examples with you about them. So gun industry sales and distribution cases are cases in which guns are sold in negligent and illegal ways. They enter the criminal marketplace, get into the hands of dangerous individuals who use those illegally acquired guns to shoot and injure our clients. And so a classic example of this type of case is a straw purchase case or a straw sale. And we argue in our cases that the role of the gun dealer goes beyond just completing a background check. Gun sales are not just meant to occur as if you were buying a sandwich from a vending machine. You know, a straw purchaser is somebody that can pass a background check. So it's the obligation of these gun dealers to really follow best practices and ensure that a case like a straw sale is not occurring. I'm going to tell you a little bit. We have a bunch of straw sale cases. We have one in Arkansas that we're gearing up for trial. We have one in Wisconsin. We have one in South Carolina. And many of these cases are against sporting goods stores that have a nationwide impact. So just bringing these single cases can change the business practices nationwide because they're national dealers. I also want to share a little bit, and John may want to jump in on this case because he did litigate it for 15 years, which is the Williams case. So the Williams case is really a first of its kind case for numerous reasons. The case was originally arose from a case of mistaken identity in New York, where a 16-year-old star basketball player was shot with a gun that had been trafficked into the criminal marketplace. Now, B. Miller was the name of the manufacturer of these Saturday Night Special guns, and B. Miller had one distributor, which was known as MKS. And MKS sold these guns at gun shows to straw purchasers, and they were ultimately, you know, trafficked into the criminal marketplace to many people who couldn't pass a Brady background check, which is how they got trafficked in. So this case had tremendous impact, both on a legal precedent level, as well as really created a fantastic settlement for Daniel and his family and industry reform changes. In 2012, the New York Appellate Division ruled for the first time since the passage of PLACA that a gun manufacturer and distributor can be held liable for selling guns to traffickers. And so Williams is a case that, you know, is cited consistently in all the cases that we do, in all cases that are really brought in this space. So it was really a fantastic, very, very impactful legal ruling. And in addition to creating great law, there obviously was a confidential financial settlement, but it brought about significant business reforms. Most of our cases, part of the settlement or just us bringing the case and is a way that that we can impact change. Oftentimes we come up with these business reforms, we reform training, people make policy changes in response to litigation, and it really has a nationwide impact, just bringing these cases and then successfully settling them. And that's certainly what happened in this case. So unless John wants to add anything about Williams, I'm going to jump over to talk a little bit about our assault and marketing cases. Okay, I'm going to jump over. So our assault and marketing cases are really a new type of case that we've certainly brought recently. We currently, in California, brought a case on behalf of the victims of the Poway synagogue shooting, which occurred in April of 2019 in Poway, California. Now, it's a very interesting suit. There are several defendants, but one of the main defendants and what makes this case novel and first of its kind is that we brought a suit against Smith & Wesson. And one of our allegations is that Smith & Wesson's rifle could be easily modified into an assault weapon in violation of California's assault, in violation of California law and a violation of federal law that would make it fire automatically. So we alleged in this case that's a design defect, but we also alleged a marketing claim. Now this is similar, I'm sure many of you have read about the Sandy Hook case. This is a similar type of claim where we allege that Smith & Wesson marketed their weapon in violation of California's unfair business practice law in a manner that attracted customers, militaristic, youthful customers similar to the shooter. So this case is just getting started. We just filed it recently, and I'm certainly looking forward to sharing updates with you all as it evolves. And additionally, our work in assault and marketing claims and assault weapons is not just limited to litigation. We all, in certain cases, we decide that we can't bring cases for whatever reason, and we decide to impact change in other ways. Now, one thing we've done is we recently filed a complaint with the FTC seeking or asking them to investigate Smith & Wesson's marketing of assault weapons. Smith & Wesson's assault weapons have been used in many shootings, including the Parkland shooting and many others. And we filed this complaint against the FTC in collaboration with Everytown to Prevent Gun Violence and Fred Gutenberg, whose daughter was killed in the Parkland shooting. So I'm shifting over to another bucket of our cases. We also have a series of cases that we like to refer to as product safety cases. Product safety cases are geared to hold gun manufacturers accountable for selling faulty and dangerous products that lack life-saving safety features. Many safety features have been available for decades, and manufacturers have intentionally chosen not to include them in their guns. And if they did include them in their guns, it would save thousands and thousands of lives. So these cases are based on the design choices and failure to warn. And, a common fact pattern, we actually have 3 cases that are very similar, one in Pennsylvania, one in Arizona, and one in Kansas, all occurred by children unintentionally being shot by other children. And, in all of these cases, I would say the shooter did not know that there was a chamber, a bullet in the chamber, and removed the magazine and thought and was playing with the gun and thought that it was unloaded. Now, there are certain life-saving features that could have been included on these guns, and had they been included, it might have prevented this shooting. So these cases were brought in that vein, and certainly these are our product safety cases. Another area of cases that Brady also litigates is in the area of online sales. Guns being sold on the internet, purchased on the internet through internet websites has certainly become an area of concern in recent years. We have filed several cases against armed lists on behalf of victims who were killed with guns facilitated by arms lists through private sales without background checks. We argue in all of these cases that arms list intentionally exploits gaps in American gun laws to arm dangerous people by facilitating illegal gun sales. So online sales are certainly one area that I think will continue, that we're already working in, and that certainly will continue to evolve as people attempt to buy guns on the internet. And jumping ahead, a new area of litigation, which is concerning, and especially concerning to people in California, are ghost guns. Ghost guns are guns that are bought in pieces. It's like a Lego set that you can assemble yourself. They're unserialized. You don't need to undergo a background check to have a ghost gun. They can be in violation of all types of regulations and laws. They don't go through licensed dealers. And they're a very easy way to avoid there's a very easy way for criminals to get guns and avoid the laws that were set in place to protect people from them. So this is certainly a new area of potential litigation that, you know, Brady is looking at in terms of how to combat the problem through litigation. And that's really sort of the summary of the different buckets of cases that we litigate.
Thanks, Erin. And yeah, if people have questions, I don't know if it all goes through the Q&A function or live, but certainly submit those. And just to talk about the Supreme Court, which I know is on a lot of all of our minds now. We're certainly very involved in this fight over the replacement of Ruth Bader Ginsburg because of its tremendous impact on the construction of the Second Amendment and other gun laws like PLACA and the Communications Decency Act that, you know, protects bad actors. So we feel, and we're issuing statements, many of you followed, we feel that for one, the American people should decide who replaces the next Supreme Court justice, and there should not be a double standard where Obama is not allowed to have his nominee heard within a year of the election, but Trump can. And also on the merits, we don't yet know who the nominee is. People always think that because we're in Washington, we have inside information, and we do know. No, we don't. We just read the same thing everyone else does. But we know whoever it is, if they're picked by Donald Trump and endorsed by the Federalist Society, they're probably not good. And what we know about the nominees so far is that virtually none of them have any sort of paper trail on the Second Amendment. The one exception is who's reported to be the top candidate, Amy Barrett, who did write one Second Amendment decision which held that nonviolent felons have a constitutional right to guns, and that the federal Gun Control Act that says otherwise is unconstitutional, at least as applied to people like the guy in this case who had been convicted of mail fraud. That's a troubling decision. It's an outlier. Most other courts have rejected that view. That said, it's just one decision, and we need more information. But certainly, we're skeptical and very concerned about it. as of now, the Supreme Court has not really taken a Second Amendment case since the Heller decision in 2008 and then the McDonald decision in 2010. So all these issues that Christa talked about whether assault weapons are constitutionally protected and other sorts of laws are permissible, Supreme Court has not weighed in on any of them. Even before Justice Ginsburg's death, we all assumed that that was going to change very quickly, and it's almost certainly will. To be honest with you, it's been, I think, a surprise to all of us in the movement that the Supreme Court has not taken a Second Amendment case in the past few years. They took one but did not decide on a Second Amendment issue. But again, we all think it's going to happen. Now with Justice Ginsburg being replaced, it will happen just as quick, if not quicker. So it will happen very soon, and we'll be in a big fight, a huge fight, and you'll be hearing a lot about it from us. So I think that covers most everything, unless Christa, anything else that you wanted to cover?
No.
Yeah,
I think you covered everything that I had remaining.
And I don't know if there are any other, I don't see any questions. I don't know if there's a voice in the sky that Jamie or someone who monitors questions live, or if there's a way to do questions live. But otherwise, I think that's it. Thank you all. I guess one closing comment is, you got an overview for the sort of cases that we do. Keep an eye out for those sorts of cases. And certainly, if you hear of them, whether there's a potential law that needs to be defended or law that needs to be challenged, or someone who was shot, and you think it may have been because a gun was trafficked and a gun dealer did something wrong, or they were shot and there was perhaps a safety feature that could have prevented it. Any case like that, even if you don't know all the facts, email us. We can talk it through, and we can see, and we can either see whether it's a case that we want to help bring, or whether we can maybe help find another lawyer who would want to bring them and assist them. So certainly do that. That would be a great help to us. A lot of times we get cases that way, and we can provide a service that a lot of people don't know is out there. I think that's all we've got. Thank you all very, very much.
Yeah, thank you all for having us this evening.
Thank you.
For all your hard work.